Hi everyone, you're welcome to my channel. My name is Mide, and this channel is dedicated to all law students and everyone who are willing to understand law in a practical and more simpler form. Today, I will be starting with the introduction to law of contract. What is law of contract? As we all know, we have contracts in the ordinary form and we also have contracts in its legal form. Contract in the ordinary form is what mostly everyone gets into. Yes, we all get into a contract, whether you are aware about it or not. For instance, maybe you meet a person and you promise that person that you are going to give the person a thing, then that is practical contract. Yes, that is a contract. While a contract in the legal form, what differentiates it from a contract in its ordinary form is its enforceability. I repeat, what differentiates contract in the legal form and contract in its ordinary sense is its enforceability. I repeat, the only difference between contract in its ordinary form and contract in the legal form is its enforceability. Why? Enforceability in the sense that a legal contract can be enforced by the court of law. It can be enforced by court whenever one of the party is in breach of it. While contracts in the ordinary sense cannot be enforced, it is merely an agreement. It is just an agreement. It is not intended to be enforced. I'll go again. Contracts in the ordinary sense cannot be enforced because it lacks all the elements that the court will look into before they consider it as a valid contract. So, law of contract has been defined by different legal professionals. One of it, which is Nikitobi, it defined law of contract as an agreement between two or more parties which create reciprocal legal obligation to do or not do a particular thing. I repeat, a contract is an agreement between two or more parties which create reciprocal legal obligation to do or not to do a particular thing. From this definition, you can see the keyword reciprocal legal obligation. This means that, for instance, maybe Mr. A is in an agreement with Mr. B. Then Mr. A has a duty to perform while Mr. B also has a duty to perform. Then that is a reciprocal obligation, meaning that the both of them, both Mr. A and Mr. B, both has an obligation, a duty to perform in that agreement, and that is why a law of contract is a reciprocal legal obligation. It is not just one party that is entitled to do a particular thing. If that is it, then it will not be able to enforced by the court. One party has to do something in return for another thing from the other party. Moving on, law of contracts is a legal binding agreement. Yes, a legal binding agreement. As I've mentioned earlier, that contract in the legal sense, the difference between it and contract in the ordinary sense in it is its enforceability. It is its binding nature, meaning that law of contract has a binding force, while contract in its ordinary sense does not have any binding force because it is basically mere agreement. So what you need to know is that any legal contract has a binding force and it should definitely be enforced by the court of law. Going ahead, all contracts are agreements, but not all agreements are contracts. I'll say it again. All contracts are agreements, but not every agreement are contracts. Don't worry, this is very easy to understand. All contracts are agreements. As I've said earlier, that a contract is a binding agreement between two or more parties. Yes, it is binding contract, and we know that yes, that is a legal force agreement. But not all agreements are contracts. I explained to you contract in its ordinary sense. It is an agreement but not a contract. I'll say it again. Not every agreement are contracts. For instance, contract in its ordinary sense. Yes, it is an agreement. We can see that it is an agreement between two or more parties as well. But the different thing there is that it is not a binding contract. It is not a contract because it lacks all the elements of a contract that can make it have a legal binding force. Alright, I will make this practical. For example, if Mr. A promised Mr. B that I promised Mr. B that I would pay your house rent. I'll pay your house rent for you. Then Mr. B accepts it without any consideration, without doing anything in return to Mr. A. That is just a mere agreement. Mr. A can decide not to fulfill the promise. Then if Mr. B is not saying, oh, Mr. A promised to pay my house rent and he is not fulfilling it or she's not fulfilling it, I want to take Mr. A to court. It will not be enforced by the court because it is mere agreement. Okay, alright, Mr. A promised to do something to pay your house rent. What have you done in return to Mr. A in order to ensure that Mr. A will keep the agreement? Nothing. That is why they say that not every agreement are contracts. Agreement that happened between Mr. A and B is not a contract and cannot be enforced by the court of law. But if Mr. A promised Mr. B that I will pay your house rent for you, for Mr. B, and Mr. B also maybe provide a service to Mr. A, then we can see that Mr. A is doing something and Mr. B will also do something. Or Mr. A wants to do something and then Mr. B would also be doing something. You can see that it is not just one-sided. There is reciprocal obligation, as I have defined earlier. There's reciprocal obligation between Mr. A and Mr. B. Mr. A is going to pay the house rent and Mr. B is going to provide service to Mr. A. Then that is a legal contract that can be enforced in the court of law. If any of the party, maybe Mr. A failed to fulfill the agreement, then Mr. B can successfully sue Mr. A for the breach of that promise. Therefore, all contracts are agreements, but not all agreements are contracts. So why is law of contracts important? One, it governs businesses and agreements. Yes, law of contracts helps to ensure that every agreement made in a business or any form of agreement are binding and enforceable. It enables the people to know their rights, their duties and obligations as expected in the contract. Also, it makes promises enforceable. Yes, it ensures that a party do not just promise the other party in vain without fulfilling the promise. It makes it enforceable when it entails all elements, all factors that the court will consider and ensure that it is promptly enforceable. And also it provides remedy for any party who is in breach of the contract. Like maybe after you've promised the person to do a thing, the contract is legally binding and then you fail to fulfill that promise. Law of contracts ensure that you can sue the person and ask for remedy for not fulfilling his or her part of the contract. So we have different kinds of contracts: formal and simple contracts, express and implied contracts, bicameral and unicameral contracts. This was just an introduction to law of contracts. In the subsequent class, I will be breaking down the kinds of contracts one by one. Kindly subscribe and like. Thank you.